Hi, this is Advocate Lucinda, your empowerment lawyer. Today, I want to talk about unlawful termination and the damages that the prevailing plaintiff may be able to recover and how to calculate those damages. And this would be particularly for those of you who have received a settlement offer from the defendant. So let's get started. Back pay. Back pay is the amount of salary and other benefits that an employee claims that they are owed after a wrongful termination or another improper change in salary status. Now, again, remember, this is for the prevailing plaintiff. The way it is calculated for salaried employees: divide employee's wage by the number of pay periods in the year, multiply this amount by the number of pay periods. Now, I have given you a link at the bottom, and it will demonstrate how this calculation is done. Now, remember, the calculation for salaried employees may be different from the calculation for hourly employees. You always want to read the local rules and the jurisdictional rules in which the lawsuit is filed. And also, this is considered compensatory damage. Compensatory damage is intended to compensate for income the plaintiff lost as a result of unlawful termination. And one other thing, the calculation begins from the date of the termination to the date the claim was finalized or judgment was rendered by the court. Front pay. Front pay is money awarded for lost compensation that the employee would have earned if reinstated to their former position. Now, there is no precise formula to determine the amount of the front pay because front pay is an equitable remedy. The judge usually determines front pay. Again, I have provided a link where the calculation of front pay is demonstrated. And this is also called compensatory damage because it is meant to compensate the worker or to make the worker whole. Lost benefits, these are also considered damages in a wrongful termination case where the plaintiff again has some success. Lost benefits include bonuses, medical and dental insurance, pension or 401k plans, stock options, and profit sharing, among other benefits. Depending on the lost benefits, the plaintiff may need to hire an expert to determine the money damage amount. Reinstatement. If the employer fires the employee illegally, the courts may order them to give the employee their job back or a similar job. It also means giving the employee back the same pay, benefits, perks, etc. An interesting case recently, Gerald Bryson versus Amazon, is a good example of how this works. The court ordered that Amazon reinstate the employee. And also, I will give you the link to this case. You need to read it, it's very interesting. Emotional distress. Emotional distress is the mental anguish employees experience as a result of workplace discrimination, harassment, or a hostile work environment. Lawsuits for wrongful termination, retaliation, and sexual harassment often award emotional distress damages. Now, the calculation is a little special. So, to calculate the emotional distress, the plaintiff will add up the economic damages, for example, medical costs and other economic damages, and multiply that sum by a given number, of which is usually between 1.5 to 5. Now, with regard to those damages that are non economic or non tangible, there is no specific formula for calculating those damages. For example, pain and suffering. Every state approaches the problem in a different way. And so, because it is a state issue, the plaintiff will look at the state's laws and rules regarding awarding emotional distress. And so, I have again provided you with a link that would demonstrate this calculation. Punitive damages. Punitive damages are an amount the employer is ordered to pay for actions that are particularly egregious. The objective here, by awarding punitive damages, are intended to punish the employer and deter similar behavior by others in the future. The award is made by the jury or the judge. Now, I have given you the link to the statute that discusses punitive damages in wrongful termination cases for prevailing plaintiffs. Attorney's fees. The prevailing plaintiff may be awarded attorney fees. The American rule on attorney fees is that each party to a lawsuit pays their own attorney's fees. In order to be entitled to an award of attorney fees and costs in a Title VII case, which is employment discrimination, it is required that a plaintiff be a prevailing party. However, a state statute which applies to a case may state another rule regarding attorney's fees. And that's why I always say, read the local rules. Read that state's rules. Advocate Lucinda, I'm here to empower you. See you next time.